Your immediate reaction to this Supreme Court ruling?
I think it is exciting, and it's a victory for Ghana, not necessarily for just Heath Goldfields.
Okay.
I say this because the mine is one of the biggest mines we have in Ghana that the people of Ghana are supposed to benefit from. And so if it's not operated, if it is not operational, or if the people who have been employed to work there are not getting the benefit of that natural resource, then it becomes a problem for the whole Ghana. And so this decision from the court is a victory for the whole Ghana. That is my initial reaction.
Now, did the court make any significant pronouncements that could set a precedent in mining transactions in the country?
Well, as far as the Supreme Court decision is concerned, the judgment is a ruling, actually. It did not really go into details because the Supreme Court felt that the application that was made to the court by FGR and Blue Gold had no merit at all. I mean, no merit. And so we did not even respond to it.
Okay.
And for your viewers and for Ghanaians to understand why the Supreme Court did not even go into the merits of the matter, I would have to give a background.
Absolutely.
Yes. So the Bogoso-Prestea Mine has been there for a long time. Yes, has been there for a long time. And it was being operated by FGR, a company called FGR. That is the Future Resource, or Future something. I've forgotten the full name, but it's FGR. And between
Future Global Resources.
Sorry?
Future Global Resources.
That is correct. Between 20 and 2023, they were not able to operate it. They owed a lot of people. They were unable to pay SNET. They were unable to pay their creditors. And the mine was not in full operation. And so those who work there, the mine workers, will tell you that most of them were owed months and months of salaries. On 3 different occasions, the Minerals Commission and the then minister responsible for lands and natural resources attempted to terminate their lease. And they came up with a plan that they wanted to collaborate with another company called Blue Gold, where Blue Gold will inject about $150 million into the operations of the mine so that they pay their creditors and then revive the mine. Based on that proposal, somewhere in January 2024, the minister and then Minerals Commission granted a conditional approval to that collaboration that they were doing, or the assignment that FGR wanted to do to transfer its lease or its rights to Blue Gold. It was a conditional approval, and that conditional approval came with some conditions that particular proposal they presented to the minister should be executed within 120 days. They should be able to pay all outstanding salaries, and they should be able to raise funds enough to pay creditors. After even that 120 days, the $150 million that they had represented to the minister that they had secured was nowhere to be found. The minister could not ascertain that particular representation that was made to it. And Blue Gold FGR was also not able to provide evidence for that.
Okay.
And so, after so many deliberations, including the advice of the Attorney General at the time, they terminated the lease of FGR Blue Gold in September 2024. So when the lease was granted to Heath Goldfields in November, FGR went to court, the High Court, which is the commercial court, stating that under the Minerals and Mining Act, there's a provision that states that when there's a dispute between a mining leaseholder and the government of Ghana, they are supposed to submit it to arbitration, or what we call an alternative dispute resolution mechanism, to resolve. And when a party requests for that arbitration to be done, there isn't supposed to be any termination, or there isn't supposed to be any action that would jeopardize the rights of the holder.
Okay. Okay. Now, Counsel, with this particular ruling, what does it mean practically for Heath Goldfields in its operations over the Prestea Bogoso mine?
What it means is that, as far as we are concerned, and as far as the law is concerned, Heath Goldfields has been in possession, lawful possession of the mine since it was granted and signed in December 2024. And the operations cannot be stopped just because FGR has gone to court. There is no injunction against the company. The company can continue to work. I must put on record that this is even not the first case. I've been to court several times. The first one, which has now ended with the Supreme Court, is what we are talking about, which was the Commercial Court 2, which was dismissed. They went to Commercial Court 6 to say that our lease has not been ratified when they injuncted us from doing the ratification. That one was also thrown out, and I'm told that they are trying to appeal that one too. They've also gone to the Human Rights Court on the same matter, the same facts. Because it is before the court, I can't talk about that. But I am saying that there have been series of actions before the court, but none of them is suggesting that Heath Goldfields cannot do his work. The mine has to be revived for the people of Ghana to benefit from same.
Did the Supreme Court make any consequential orders?
No. It was just thrown out because it was a judicial review application, and
of the High Court ruling
sought to quash the ruling of the
High Court.
Yes,
Okay.
Yes, because the court did not find any merit in it. It was just thrown out. That's it.
Are there any outstanding legal tussles ahead? I know that there's an international arbitration request.
Yes, I have severally referred to justices in court that this is clearly a situation of, if I don't get it, then you will not have it. That has been a posturing of FGR Blue Gold. And so anytime they go to court and they are thrown out, they find another means to go back to court. And so that is why I said that there is another matter pending before the Human Rights Court as we speak, which I can't talk about because it is sub judice. And then there is also an arbitration that is between the government of Ghana and FGR Blue Gold, not Heath Goldfields. So that is not within your domain.
My territory. Absolutely. Now, do you now have complete acquisition, or you'd have to fulfill certain obligations with, say, the Minerals Commission, for instance?
As far as I'm concerned, the lease has been executed. Processes are in place to get it ratified. He has fulfilled all the conditions in the lease and the approval, and they are still in the process of reviving the mines. And so if there are any technical issues or any technical outstanding issues that are supposed to be resolved, I'm thinking that the right person to answer that question would be the technical guys.
How does this ruling secure the interests of, say, the people of Prestea and Bogoso? So we know that that's the central point for employment for people who live in that enclave.
I didn't get your question.
I'm asking how this ruling secures the interests of people who live within that enclave. We know that mining is their central employment for people in Prestea and Bogoso.
Like I mentioned earlier, I think this is exciting because before this ruling came, Heath Goldfields was in a process of paying off those who are owed and trying to revive the mine to its fullest limit for the people who are employed there to benefit from same. And so what this means is that one impediment is gone. I believe that one of the hurdles is now gone, and it gives the company some breathing space to continue to do the good work that they are already doing to make sure that the people fully benefit from the natural resources that God has blessed the country with.
Okay, Prince, thank you. That's Prince Benson Mankotam. He is a lawyer for Heath Goldfields Ltd.